Okay, I'd like to welcome all LSAC members and all viewing the meeting remotely. Before we begin, I have a few notes to announce before conducting virtual meetings. The meeting must comply with the requirements of the Open Meetings Act. Accordingly, the public may view the meeting via a link provided in the advertised agenda, which can be found online at the KDE website. LSAC members must ensure their video is streaming and they can be seen throughout the duration of the meeting. LSAC members may mute their microphone when not talking. However, all discussions must be broadcast to the public. Therefore, superintendents should ensure their microphone is not on mute when speaking. For any items that require a vote, a roll call vote will be necessary to record the vote of each superintendent. Please mute or turn off cell phones or other mobile devices so as not to disrupt the meeting. So as we begin, I'd like to introduce the Commissioner Dr. Jason Glass for an update from the Kentucky Department of Education.
Thank you, Mr. Chair, and good morning, everyone. It's good to see all of you. I know that this topic that we're about to delve into has a great deal of contention and political attention attracted to it. And as I've heard from folks around the state as the department began work on these regulations that are before you today, questions have come up around what's the department's position on them and what is my position on them. So I'd like to just take a few moments of my introductory time here to make abundantly clear what that position is as you begin considering them and provide recommendations to the state board. The regulations that we put forth for consideration ultimately by the Board of Education should not be confused as my recommendation for charter school best practices. These regulations were developed with the staff at KDE and represent our attempt as an executive branch agency to comply with the law that we were given by the General Assembly in House Bill 9 from the last session. Like many of you, I believe that there are significant constitutional issues associated with House Bill 9. For example, I question whether the charter school law as set forth in House Bill 9 even meets the definition of a common school to qualify for state education funding under the state constitution. In the Rose case, the court held that a common school must, quote, be available to all Kentucky children and, quote, be substantially uniform throughout the state, providing, again, quote, equal educational opportunities to all Kentucky children regardless of the place of residence. I question whether operating parallel systems is supported by public education funds violates the requirement in Rose that a common school be operated, quote, with no waste and no duplication. I also question why the boards of Kentucky's 16 largest public school districts, accounting for over 46% of the student population, don't receive the same benefit under House Bill 9 that the remaining 155 boards receive. That is ultimately the authority to determine whether a charter school can apply to operate within their school district and whether this limitation violates Section 59 of the Kentucky Constitution. I also question the ability of a mayor or consolidated local government to authorize a charter school and direct locally levied tax revenues away from the public school district, given the Kentucky Supreme Court's holding that common schools must be operated, quote, with no political influence. I also question whether Section 180 of the Kentucky Constitution prohibits the forced transfer of local tax revenues, even for non-resident students, from a school district to a charter school, as is called for in House Bill 9. And finally, I question whether the forced transfer of educational funds from our public school districts to charter schools meets the requirement detailed in the Rose case that our existing schools must be adequately and equitably funded. Nevertheless, Mr. Chair, these are constitutional issues that have to be answered by the judicial branch, not us. The Kentucky Supreme Court has consistently held that statutes are generally afforded the presumption of constitutionality until determined otherwise by a court. Therefore, it's up for the court system to decide whether or not House Bill 9 and these regulations are constitutional, not the legislature, not me, not the Kentucky Board of Education. Unfortunately, House Bill 9 was very prescriptive and left little to be decided by the policy experts at KDE or with the board. The proposed regulations are drafted to fulfill our obligation, the department's obligation, and the state board's obligation to promulgate regulations carrying out the legislation. I've heard from numerous superintendents and education stakeholders throughout Kentucky arguing that House Bill 9 is legally questionable. Like I said, I too have those questions, but those questions are for the judicial branch to answer. And currently I'm not aware of any lawsuits related to House Bill 9. In the event a suit is filed challenging House Bill 9, KDE will follow that closely, and we welcome any clarity that the court may provide to help settle some of these issues. Like in your school districts, resources at the department are limited. In the event that KDE or me as commissioner are named in a lawsuit challenging House Bill 9, we will carefully review that matter and determine how best to proceed. Provided the questions before the court relate strictly to the constitutionality of House Bill 9, I will likely not expend the time and resources of KDE staff to defend the issue for the reasons that I've laid out before. Instead, that will be a matter for the Attorney General to take up. With that background in mind, Mr. Chair, I'll turn things back over to you for the deliberation of the LSAC.
Dr. Class, so thank you so much. I do have one comment that I'll make, and I think it's important for our members to understand is as we move forward, KDE is obligated to promulgate regulation based on statute. So again, I echo almost word for word what Dr. Glass had said earlier. I do have those same type of questions, and I think we need to keep that in mind as we move forward. So with that being said, thank you, Dr. Glass. I appreciate your insight. I appreciate your comments, and again, couldn't agree more. And thank you for that. We do have the regulations for review and action possible. We have 10 regulations for review and action, and Kentucky Board of Education policy does not require 2 readings of regulations. The board has discontinued the practice of 2 readings unless the board chair determines that additional readings are necessary. The following regulations, although first readings, will not have second readings and will require action by the council. From the Office of Continuous Improvement Support, we have Kelly Foster and Matthew Courtney, who will present the first set of regulations. So I'll turn it over to Dr. Foster and Dr. Courtney.
Good morning, everyone. Thank you. Just to kind of reiterate what has already been said, the regulations in my office are not new regs. We're bringing 8 in front of you today. 4 of those are emergency, but what we have done with the current charter school regulations is we have updated those to align with House Bill 9. And my policy advisor, Matthew Courtney, is with us today, and he is going to walk you through those changes. So Matthew.
Thank you, Dr. Foster, and good morning, members of LSAC. Before I get into the regulations, I do want to just elaborate briefly on what Dr. Foster said related to our 8 regulations. So what we've brought for you today are 4 existing regulations that have been amended to meet House Bill 9. Each of those regulations then has a companion emergency regulation, and that goes along with it. So it's really 4 bodies of text, but each one has 2 versions, and those versions are identical. The reason we are promulgating emergency regulations along with following the ordinary process for a regulation is in order to meet the statutory deadlines required by House Bill 9 that would allow a charter school to open in the following school year. So we have to move these forward in both emergency and ordinary forms in order to meet that statutory timeline. So Meredith, if you'll take us to the next slide, please. And this is what I just said. Meredith, we can go on to the next slide. One more. Thanks, Meredith. Okay, so I'm going to go through each of the regulations. We're going to do them in numerical order. So you'll see here, this is both an emergency and an ordinary regulation. This regulation 701 KAR 8010 is related to student charter school applications. So this is how a student would apply to attend a charter school. Next slide, please, Meredith. So I'm just going to go section by section. The slides highlight only the changes that are being made. So you can see here we have in section 1, that's our definition section. We have tweaked the definition for enrollment preference. That's that first bullet there to add the words other and application. That is, of course, to conform to House Bill 9. And then we have struck the definitions for startup public charter school and traditionally underperforming, again, to align to House Bill 9. Those are terms that are no longer necessary in this regulation. And next slide, please, Meredith. In section 2, we have struck this entire chunk here related to enrollment preferences. These are enrollment preferences that are no longer available due to House Bill 9. So in order to conform to House Bill 9, this language all is required to be struck. Next slide, please. In section 4, we have added a enrollment preference here and tweaked some other language related to resident and non-resident enrollment policy. So under House Bill 9, charter schools do have the ability to enroll students, but they must do so within their resident and non-resident policies. So that's a new, some new language, that resident and non-resident enrollment policy. So that which has been added here. And then we've also added some language here that stipulates that a charter school cannot require a family member or a person with custody or charge of a student to volunteer or provide payment to enter the school. And so that person with custody or charge of the student is an important clarification necessary to conform to House Bill 9. Next slide, please, Meredith. Okay, so that was our first regulation. Dr. Fletcher, I think I'll pause here and see if there are questions about that regulation before we carry on to the next one.
Thank you, Dr. Courtney. Any questions from any of the LSAC members? Dr. Courtney, you're going to hear this question pretty common from me, if you wouldn't mind. My first question is, does this meet the minimum requirement of statute?
Yes, sir, it does.
Is there anything in excess that we've added, that KDE has added, that goes over and above the statute?
No, we have not added anything that we are not required to add by House Bill 9.
All right. Any others? All right, Dr. Courtney, if you may proceed, please.
Okay, thank you, Dr. Fletcher. So our next regulation is 701 KAR 8020, evaluation of charter school authorizers. And again, you'll see both emergency and ordinary versions. They are the same. So this is the regulation that deals with how a charter school would apply to an authorizer and then the behaviors of that authorizer moving forward. So a few changes here. Section 1, we've added a definition for district of location. That is a new concept that was created under House Bill 9. Basically, a district of location is the district in which a charter school is housed, whether or not that district is the authorizer. We have removed the terms Regional Achievement Academy and Regional Achievement Zone. Those terms were removed by House Bill 9. So those concepts no longer exist in our charter school statute. And then we have refined our definition for a startup public charter school. So the original regulation referred to a definition that was cited in the statute. That definition was removed by the statute because the phrase was removed, but conceptually, we still need a word to refer to a public charter school that did not exist as a non-public charter school prior to becoming a charter school. So a brand new entity, we need a term for that. And so this is the original language that was in the statute. We just put it here in our regs so that we still had a clear definition in term to refer to that type of school. Next slide, please, Meredith. Here we have added language requiring that the authorizer ensure the establishment of a food program. Under House Bill 9, charter schools are required to offer a food program, just as our public schools are, so that students from low-income backgrounds have the opportunity to have hot breakfast and lunch at school. So we have enshrined that here as an expectation that the authorizer is monitoring and ensuring for that. We've also tweaked some language around the timeline for submission of applications. The word acceptance and the phrase includes clear definitions were both added to this similar statement in the statute through House Bill 9. So again, we're just conforming. Originally it said submission, review, decision. Now it says submission, acceptance, review, and decision to align to House Bill 9. Next slide, please. What we see here in section 4 is some struck language. This is a requirement that was removed from House Bill 9, a new requirement, which is our Memorandum of Understanding requirement. So what House Bill 9 did was create a process for smaller school districts, those with 7,500 students or fewer, to engage early on in the charter school process. And so if you are trying to open a charter school in a district with 7,500 or fewer students, you must have a memorandum of understanding with that district that is part of your application to open a charter school. And so we've added that memorandum as a requirement here. And then you'll see here at the bottom, we have struck this language for review and approval because the commissioner no longer has review and approval authority under House Bill 9. So that again is struck to conform to that language. Next slide, please. In section 5, you can see that we struck some language here around commissioner's authority. So again, that authority was struck in House Bill 9, so it has been removed here. And then we have struck some language or swapped some language out in that bottom bullet where it originally said revenues to fall below 2%, and now it says expenses to exceed 98%. So that's just some clarifying language, again, aligning to the intent of House Bill 9. Next slide, please. Okay, Dr. Fletcher, I'll pause here again.
Thank you, Dr. Courtney. I'll open it up for any member for any questions from LSAC members.
Dr. Courtney, this may be a little unique to Northern Kentucky, but when it talks about the authorizer running a food program, the authorizer designates a charter school to be in a district of location. The authorizer is still in charge of that food program, not the district of location?
So the charter school is in charge for running and administering the food program. The authorizer is required to ensure that they do so. So it's a monitoring and enforcement requirement on the authorizer.
Thank you very much.
Mm-hmm.
Great question, Superintendent Borchers. Others?
I'm not sure, Dr. Fletcher, if this is the right time or not, but stepping back to 8:010, there was a piece in there about resident and non-resident boundaries, Dr. Courtney. How does that, is that suggesting that there is a limitation on the area that feeds the charter school?
So during the application process, the charter school is required to set their enrollment boundaries, and they are allowed to have enrollment and non-enrollment policies. So the language that we added to the regulation says that they can only enroll in alignment to their policy. So they have to have that policy that's part of the application process. It kind of depends because there's different kinds of charter schools. So if you're an urban academy charter school, that's a new category. Conceptually, that charter school should only enroll students within a close proximity. That phrase is not really clear or defined. I kind of conceptualize it as like we could walk to school, that sort of neighborhood school concept. So what you would do as an urban academy is you could say, okay, we're gonna, these are the streets, right? Inside this square of streets, that's where we're gonna pull kids. That's our enrollment zone. But then we would have a resident and non-resident enrollment policy. So if you lived outside of this established enrollment zone, you would have to enroll under our non-resident enrollment policy. And the charter school has the ability to set that policy. It could be that we do not accept non-resident enrollments, and if you're outside of our zone, you cannot attend this school. Or it could be that maybe they get secondary preference. So if we fill up on resident students, then non-resident students are not eligible, or if we still have seats, then we pull from that second pool. So that is really at the discretion of that charter school, their board of directors, their management company.
And as a follow-up to that, could a non-resident area be interpreted as being statewide?
I think, yes, within their scope of policies. They have to set that policy during their application process, and then we're requiring them to adhere to their policy when they enroll students.
That kind of goes back to the, the House bill, I believe it's 563, that we all have now before us, and just how that would impact the charter school application as well. So thank you.
Sure.
To kind of go along with what Dr. Burchett was talking about, there's been a lot of questions of what, I think the 7,500 minimum for a district. I think Dr. Glass alluded to the number of districts that would impact, I think 16 districts. But when you throw in House Bill 563 and you look statewide, it could, and again, there's a lot of argument about this, but could this also impact a smaller district that's in rural Eastern Kentucky or a smaller district in Northern Kentucky, even though we're not anywhere near 7,500 students? Dr. Courtney, any comment about that?
I might look to Todd Allen to see if he can speak to that at a deeper level. But I would go back to their enrollment policy and what that policy is. We don't have any control over their enrollment policy, and so they would be able to set that. Todd, do you have anything you might want to add to that one?
Sure. What may help to clarify a little bit is that the 2017, I believe it was, version of our charter school statutes only permitted students to enroll in a charter school who were within the district boundaries. So if a charter school was authorized by and operated in District A, it could only draw students who are residents of District A. With the amendment in House Bill 9, it has now been opened up to allow the charter school to draw students from anywhere, non-residents, which would include the state, the entire state. Now, of course, there are practical considerations. If a student lives in Paducah, he or she isn't going to be able to make it to Pikeville every morning for school. So there are those practical considerations. But yes, they could draw from any district in the state for their student population. They just need to identify that in their policies with their application to the authorizer, as Dr. Courtney has indicated.
Thank you, Mr. Allen. And that's one of the things that in a lot of the discussions I've been a part of, there's legislators that have used the argument that this will not impact smaller districts. This will not impact if you're less than 7,500. So I do hope that, as we look at this, we realize this impacts everybody across the state. And even so, I'm not trying to, I think overall charter schools, I do not believe that the way it's set up, that it is constitutional, although I don't have that authority to say it's unconstitutional. But so no matter if it's the 16 largest districts or the remaining of the 171, I think this is bad for all of us. But with that being said, I do go back to the same question, Dr. Courtney, that I asked before. Does this particular regulation meet the minimum requirement of statute?
Yes, it does.
Does it exceed it in any way?
No, it does not.
Other board members, any questions?
Dr. Fletcher, I have one more follow-up to that line of questioning.
Yes, sir.
Assuming, Dr. Courtney, that a charter school is approved, and let's just say that it is adjacent to the border of another state, can their non-resident agreement or their non-resident boundary include accepting students from other states?
I'm going to throw that one to Todd too.
So that's not specifically provided in the law. I think that the department's interpretation on that would be that enrolling students who are not residents of the state would not be permitted. That is essentially using the Commonwealth's education tax revenues and dollars to educate students who are not residents of the Commonwealth at all. And obviously, from an economic policy perspective, we've got an issue with that.
Well, thank you for clarifying that, because I think that's a concern as I hear from other superintendents, particularly about the transfer of funds, and I'm sure you're going to get into that in a minute, but the concern about a local taxing authority taxing its own citizens and then being forced to transfer funds to a non-elected entity to expend those funds. So anyway, I'll wait until future moments to discuss that more. Thank you.
I think Superintendent Burchett as an authorizer would have to comb through that and challenge that, but that would seem like it would be grounds to deny the application if that was happening. So again, good point, Superintendent Burchett. Others?
Dr. Fletcher, I saw something pop up here on the screen for clarification purposes. You know, that using that Paducah to Pikeville example, I saw something on here that says that a charter school cannot be a virtual school. Is that correct?
Yes, that is correct.
Okay, all right. Thank you.
Thank you for pointing that out, Superintendent Riley, and thank you, Dr. Courtney, for that. I did not realize that, but thank you for pointing that out. Others? Dr. Courtney, please proceed.
Okay, our next one, 701 KAR 8030. Again, emergency and ordinary regulations here. And this regulation deals with the charter school appeal process. So if a charter school wants to appeal a decision made by their authorizer, this is the procedure they would take. Just some very minor changes here. In section 3, this notice of appeal deadline has gone from 7 days to 45 days. And so this language has been reworked here to align to House Bill 9. Next slide, please. Oh, and that's the only change for that one. So that'll be quick and easy. I'll pause again, Dr. Fletcher, to see if there are other questions.
Questions from LSAC? Well, again, my same question. Does this regulation meet the minimum requirements of the statute?
It does.
Are there any, does it exceed the statute in any way?
It does not.
Okay. Others? All right, Dr. Courtney, please proceed.
Our final one, 701 KAR 8040. Again, emergency and ordinary regulations. This is our regulation related to conversion charter school petition, conversion and operation. Next slide, Meredith. This one only had technical changes, so no content changes, but you'll see lots of strikeouts, number changes, statutory reference changes here, but no content changes. This regulation is essentially the same as it was before.
Okay, Dr. Courtney, I'll have one more question. In some of the discussions I've had, there are some statutes that put in date deadlines. Is that, where are those located and what's the rationale for those deadline dates? Because I believe that exceeds statute.
So our deadlines in the 4 regs that I've covered are all calendar days. So it'll say 45 days, 5 days. Those align to the statute. I believe the dates that you're thinking of are likely tied to the next regulation you'll be discussing related to funding.
Okay, any questions for Dr. Courtney? And again, I assume that these edits meet the minimum requirement of the statute.
That is correct.
And do not exceed the statute.
Also correct.
Any others? Any other questions for Dr. Courtney? Now, I believe, Dr. Brewer, correct me if I'm wrong, are we to move on these statutes before we move on to the finance statutes, financial statutes?
Correct. So it is our recommendation that you take one motion to approve the entire slate of 8 that Dr. Courtney just presented.
Okay. Okay. Any other questions for the group or comments? I do have a comment before we get started with the motion. In the research that I've done over the past few days, I do believe that, I'll make it very clear, I'm not in favor of charter schools, especially the way they're written in statute. I do not believe that the way it's set up, especially when it comes to the finances, and we'll talk about finances here shortly, that they are constitutional. But unfortunately, as LSAC chair, I don't make those decisions. That is a judicial decision. So I think the decision before us today is, do we believe that the Kentucky Department of Education has met their requirement from statute in promulgating these regulations? So when we make this motion, I'm not asking anyone to say they approve of charter schools. So the motion essentially is, do we believe that the Kentucky Department of Education needs to make any changes to these regulations in order to meet statute? So those are my comments. Anybody else have any other comments before I ask for a motion? Okay, do I have a motion to approve the emergency regulations, Title 701, Kentucky Administrative Regulation, Chapter 8, Regulation 10E, 701 KAR 8020E, 701 KAR 8030E, and 701 KAR 8040E, and the proposed amendments to 701 KAR 8010, 701 KAR 8020, 701 KAR 8030, and 701 KAR 8040.
Dr. Fletcher, David Raleigh with LaRue County. I'd like to make a motion that that we accept all the ordinary and the emergency regulations as presented today.
We have a motion by Superintendent Riley. Do we have a second?
Will Hodges, Greene County, second.
I have a second by Superintendent Hodges. Dr. Brewer, if you could do the roll call vote, please.
Mike Borchers,
Mike Borchers, yes.
Harry Burchett,
Harry Burchett, yes.
David Cox,
David Cox, yes.
Robbie Fletcher,
Dr. Brewer, before I vote, I would like for the minutes to reflect the fact that I do not favor charter schools, but I do believe that KDE has fulfilled their obligation to regulate, to promulgate regulation based on statute. So for this reason, I vote yes.
Will Hodges,
Will Hodges, yes.
Sheila Mitchell,
Sheila Mitchell, yes. I would also like for the minutes to reflect that I publicly do not support charter schools as well, but I do believe that this does reflect the minimum requirement that that KDE must send to us for approval.
David Raleigh,
David Raleigh, yes, and I'd like to echo the sentiments of Dr. Fletcher and Ms. Mitchell as well.
Kelly Ransdell,
Kelly Ransdell, yes, and I'll make the same request. Thank you.
Russ Tilford. I believe Superintendent Tilford is not present.
Okay. So the vote is Dr. Brewer?
8 yes votes.
All right, thank you. Okay, next we have Robin Kinney and Matt Ross from the Office of Finance and Operations who will present the final 2 regulations. So, Ms. Kinney.
Thank you, Chair Fletcher, and good morning to members of the LSAC. I also have with me, in addition to Matt Ross, my policy advisor, Che Ritter, he is the Director of District Support Services here in my office. We're going to talk a little bit about the public charter school funding. If we can go to the first slide, please. If you can recall, when the public charter school legislation was first passed back in 2017, there were no provisions at that time about funding and how funding would work. And so in the regular session in 2022, funding provisions were provided to the charter school legislation. So this has resulted in us, as directed by the General Assembly, to bring to you today for discussion and review 701 KAR 8:050. And we will also, like Dr. Foster and Dr. Courtney mentioned, we will have this emergency and ordinary regulation as well. We are going to walk you through really looking at the statute primarily because the statute really does dictate a lot of the funding mechanics for charter schools. So we will look at, there's a proposed emergency and an ordinary regulation, and the regulation does conform to the requirements of authorizing statutes to govern the funding calculation, distribution, and fines for charter schools. Next slide, please. So I thought we would walk through the statute because really the statute is very controlling when it comes to the directive of the General Assembly on how to fund charter schools. I thought it was important that we look together at the statutory requirement that directs the state board to promulgate those administrative regulations to go, and it specifies what we're supposed to address. So we are supposed to address the calculation and distribution of funds due to public charter schools from school districts, the schedule of distribution of funds, and the imposition of fines for the late distribution of the funds. Next slide, please. So as we start walking through, and I'm going to focus on the statute a lot at the beginning and point out to where we have made the provisions in the regulation, because a lot of the regulation, as you review it, you'll see it is referencing you back to provisions of the actual law. So we have tried to include the statutory cites, and then as pertinent, we have also included the regulatory citations as we work through the provisions. The charter schools funding starts with sort of this division and look at how the charter school will be permitted to act in its capacity for different fund sources. So the statute requires, for the purposes of local and state funding, a public charter school shall serve as a school of the district of location. And you heard Dr. Courtney talk a little bit about what that district of location is. That is where that charter school is housed or located. But for purposes of federal funding, the public charter school is going to act differently. The public charter school shall serve as a local education agency, or an LEA. An LEA, of course, is a term of art primarily used by the federal agencies when they talk about local school districts. So as the statute says, thou shall serve as an LEA, but they will act like a local school district. Next slide, please. So let's talk about SEEK first, because the statute does talk about how the charter school will receive SEEK funding. Generally under SEEK funding, the charter school will serve as a school of the district where it is located, and for funding purposes will act very much like any other public school in the district. The statute provides for inclusion of those charter school students in the average daily attendance, and also in the aggregate and ADA for transported students. So, and then it goes on to say, and I'm quoting, I don't have this up on your screen, but it says, in the same manner as any other public school in the district, and shall be reported by the public charter schools to the district and KDE for purposes of calculating the state and local share of funding. So the statutory language basically requires that this charter school will look very much like other schools in your district of location. As you know, as we determine amounts for SEEK funding here at KDE, we are looking to the preceding year, typically, as we look at calculations for your SEEK funding at the district level. However, for the first year of a charter school's operation, they're not going to have that historical data like a district typically does, or a school within your district contributing to your district counts. We will talk a little bit about what that first year of operation looks like a little later in the presentation. Next slide, please. Okay, how do we distribute the charter funding? This is also in completely out of the statute. So for each funding source identified, and they go through on this slide, the funds that are related to students' attendance and enrollment and allocation to the district of location pursuant to KRS 157-360, that is of course the SEEK statute. So that first line is transferring for the SEEK statute. Any add-ons or funding factors provided for in the state budget, any add-on or funding factors provided for by the Kentucky Department of Education, and then funds pursuant to KRS 157-362A, which is at-risk students, B, which is our exceptional child counts, and 13A, which is our home hospital counts. So that encompasses all the SEEK provisions. Not transferred, you would not transfer, and you would take out before any transfer local capital outlay, FSPK, and additional levies necessary to meet debt service, bond obligations, or any other financing mechanism for school facility projects. So you would take that off the top before you transfer. The statute also notwithstands the normal timing process for allocation of funds to your SBDM councils. So you transfer before you make any allocations to SBDM. Then SBDM comes after your transfer. That is not withstood in the statute. Again, these are all provisions that are contained in the statute itself before we get to any regulations. Next slide, please. The statute goes on to say also transfer on a proportionate per pupil basis. Education funds allocated for, again, we've talked about FSPK. It would also be for equivalent tax rate. And then it has, I will say, the drafting a little awkward in my opinion, because it talks about FSPK and equivalent tax rate, and then it has a clause at the end of this first bullet, again straight from the statute, that says, or pursuant to any applicable federal statute. So it kind of shifts right in the middle of that sequence. Then it drops down to all taxes and payments in lieu of taxes transferred to the district or levied and collected by the district of location. Of course, that is your local tax revenues that would be received, or any payments in lieu of taxes. All that on a proportionate per pupil basis. Still reflecting and reading directly from the statute. Next slide, please. Transportation funding. How will transportation funding be handled? If a district provides transportation to charter students, then it receives SEEK transportation funding just as for any other district transported students. So your charter school would act just like a school within your district of location, and SEEK would flow direct to you and then down to the charter school. There are other options though. Districts and charters could agree on a transportation funding per your charter contract or a separate agreement. So you could choose to fund that differently based upon agreement between the district of location and the charter. But if the charter provides transportation, the district of location will transfer transportation funding. If there is no transportation provided by the charter school, then of course no funding is transferred. All of this, again, citing back, and there's the statutory citation at the bottom of this slide. I'm going to keep going unless somebody jumps in.
Ms. Kenny, if I could stop just a second and ask a question, if you wouldn't mind.
Sure.
One of the concerns that I have, not particularly with this regulation, but with statute, and maybe you could shed some light on this, in the in section 1, I think subsection 12, they define proportionate per pupil basis means multiplying an amount of funds by a fraction, with the numerator being the average daily attendance of the public charter school and the denominator being the average daily attendance of the school district of location. Similarly, in subsection 13, it says a similar type definition of proportionate per pupil transported basis means multiplying an amount of funds by a fraction, with the numerator being the aggregate daily of attendance students transported by public charter school and denominator being the aggregate daily attendance of students transported by the school district location. My question after reading all that is it possible for a student to transfer to a charter school and the charter school to receive more money for that student than what the student would have, than the school district of location would have received if they stayed in their original school?
Dr. Fletcher, you'd asked that question earlier, and we are trying to make that, we are trying to work through the formula and the math to see if that is possible. We have also reached out to others because we have heard that stated from others that they believe that is possible to happen, but we have not determined yet that that is actually possible.
And, of course, if you read that, when you start multiplying by a fraction, if the way I read that is if the average daily attendance of the public charter school is better than the average daily attendance of the school of location, in other words, it'd be multiplied by a factor of 1 or greater, then would appear, again, on the surface, that a charter school could receive more funds for a student if they moved to them than if they stayed in their original then the original school location, district location received if they stayed in their district. So, that's just one of many things that I see that's an issue. Again, I appreciate you folks going through the math and seeing if that could be the case. Again, that's one of the concerns I have. One of the many concerns that I have.
We will continue.
Are there any other questions? I'm sorry, Ms. Kenny.
I'm sorry. We'll continue to work on that and see if we could present a mathematically correct slide either at the Kentucky Board of Education. I'm sure they will have similar questions on that.
And just for clarification, that's an issue with the statute itself. I'm not talking about the regulation. This is an issue with the statute as opposed to the regulation. So any other questions before Ms. Kenny moves on? Any others?
Dr. Fletcher, on the transportation, would the charter school, if they provide their own transportation, I know they have a lot of the regs waived, would they still be required to, if they say they used a school bus, would they still be required to have bus drivers CDL trained and follow the same transportation records as the public schools?
So for charter schools, they are subject to any of the regulations that apply to safety of students. So we would interpret that to mean anything on school buses that will require the CDL license, any inspections of buses, anything along those lines would be related to student safety.
Thank you, Superintendent Borchers. Others? Okay, Ms. Kenny, if you wouldn't mind to proceed.
Thank you, Chair. The other provisions of the statute, which KBE is directed to also adopt administrative regs on the schedule of distribution of funds. So the statute requires that KBE adopt a schedule. In the regulations before you today, the statute itself, let's back up to the statute first. The statute says that they should be transferred through the school year according to a schedule determined by the state board. The schedule date shall be within 30 days of the dates of state disbursement of funds to school districts. So as many of you know, we disperse SEEK once a month. And so within 30 days of the date of the state disbursement, the district will be transferring those funds, that proportional share, to the charter school. So that's set forth in the statute. The regulation in our section 4 of both our ordinary and our emergency reg basically repeats that and says the district of location shall transfer state and local funds within 30 days of receipt of funds pursuant to KRS 157-410. So we have included in the regulation, since we have to come up with a date of a schedule for both state and local funds, have tied the local fund distribution to the same 30 days, within 30 days of your local funds that you would receive as well. So you could collect funds that are received, because we know your local revenue does not come in on a regular once a month type schedule like SEEK does. So as long as you are transferring within 30 days, you are in compliance with the statute and the regulation. I would encourage district of locations to work with their finance officers on what a schedule might look like within your district. But as long as you're meeting that within 30 days of disbursement, you'll be fine and in accordance with the reg and the statute. So let's talk a little bit about the first year of operation. We had talked previously about how, as we look at amounts for transfer for C specifically, and we are always looking a year prior when we determine those allocations. Of course, for our charter schools, they would not have any history, and so the statute itself contemplates this and contemplates that for funding purposes for the first year of operation, from the beginning of instruction through December of that first year, funding will be based on a projection of enrollment and the district of location's ADA. So you're going to look at the charter school is going to, in their application, provide a projection of what their enrollment would look like. They are also going to provide projections on demographics. So all those other type of funding factors that are considered in the SEEK formula, they're also providing a projection on that. Those projections would last from the first day of instruction. It would roll up through the district of location to KDE. We would use that to calculate, and then it would come back down to the school district for transfer to the charter school. That would only happen through December, and then the calculations would be adjusted in January of the first year to reflect the charter school's first semester actual data. So they rely upon what's in the application as approved by the authorizer, and then the district and the charter would switch to actual data after the first semester in January. Once we get through that first year of operations, the charter school gets through that first year of operation, subsequent years of operation would be calculating using actual data from the prior school year, just like another public school within your the district of locations, their other schools. So it's just for this first year that you have this kind of projection through December. You switch to actual for January through the end of that year, and then they would be picked up as a public school in the district location moving forward. Again, we've included the statutory citation at the bottom of that slide. All of that is defined by statute. Next slide, please. Authorizer's fee. So this is also set forth and provided in the statute. Up to 3% of funds for transfer to a public charter school may be retained by an authorizer and then as an authorizer's fee. This is for a district of location who acts as an authorizer, or it could be for another defined authorizer by the statute, which could be those specified university, mayor, other eligible authorizers. So up to 3% of transfers to public school may be retained. If an authorizer of the public charter school does not include the local board of education of the district of location, then the district of location shall transfer the authorizer fee to the public charter school's authorizer. Again, we've included the statutory citation there on the bottom of the screen. Additionally, one other thing about the authorizer's fee, if an appeal comes to KBE, to the Kentucky Board of Education, on the denial of a charter school application and requires KBE to act in that capacity, then the KBE shall receive 25% of the authorizer's fee, so 25% of the 3%. That's also included in the statute itself, so not added regulatory. Okay, let me pause for just a minute, see if anyone has any questions.
Thank you for the pause, Dr. Kenny. Others, any questions for Dr. Kenny?
Dr. Fletcher, I'd like to go back to the transfer of funds and the timelines. Just to be clear on that, I know I think I understand from the statute the 30 days from receipt of KDE on the SEEK disbursements. But did I understand you correctly in saying we would have 30 days from the date we receive local funds from our local collector, be it the sheriff or some school districts collect themselves, whatever that may be? Would we interpret it to receive? We usually get our sheriff collections once that time rolls around, once a month. So it would be 30 days from the date of receipt from the local sheriff?
That's right.
Okay, thank you.
Dr. Kenny, is that part of statute, or is that something that KDE added as part of the regulation?
We added that as part of the regulation. The statute directs us to come up with that time schedule. And so we have kept it consistent with the state disbursement of within 30 days.
Dr. Kenny, I have a few questions if it's okay.
Sure.
Since I just want to use the Northern Kentucky scenario since it's pretty unique. So you talked about a university. University authorizes a charter in District A. So now District A becomes the district of location, correct?
Correct.
Okay, District B has 5 students that go to District A's charter. Whose local funds go to the charter? Is it the district of location's local funds or District B's local funds?
The district of location is transferring their own funds.
Okay, so in theory, a university, we'll use the Northern Kentucky University, they'll decide what district that charter school's in, and then that district will have to use its local funds to fund that charter school, even if students do not reside within that district.
That's my understanding of the way the statute is currently written.
Okay, and then the university would get 3% of the authorizer's fee based on all these regs.
That is correct.
Because there was some confusion earlier that District B's local funds would go, but that's not what we're understanding with this reg. I just want to be clear because I know I'm going to get a lot of questions. So District A is the district of location. Once those kids go to the charter school, once those students are in that charter school, the district of location's local funds will be required to fund that school, even though those students don't reside within that district.
The statute itself, and I'll invite Todd Allen to join me in the discussion, but the statute itself does not contemplate the transfer of funds from other districts outside the district of location to the district of location.
Okay, I just wanted to be clear with that because I know there's going to be a lot of questions with that. And I understand Dr. Glass and Ms. Kenny, you guys have been great with some of my questions, and I appreciate that. And I understand you're just trying to do the regs. I just want to make sure we're clear moving forward because our situation is so much more unique than the other situation in the state with the pilot projects. Thank you very much.
You're welcome.
So this is
Thank you,
Kelly
Superintendent
Ransdale.
Borchers. I'm sorry, go ahead, Superintendent Ransdale.
So in theory, the charter schools enrollment, since it can take students from other districts, could exceed the enrollment of the district of location.
I guess that's possible. That's
The
possible.
non-charter enrollment.
That's mathematically, I do believe that's possible.
And there is no transfer of funds from the sending school districts.
The statute does not contemplate any transfer of funds, any required transfer of funds from any district that is not the district of location.
I'm just having trouble understanding how that would work. If the number of students in that school exceeded, because the local district's not receiving any funds for those kids. I get, okay. Sorry, I'm not being clear with my wording, but
No,
I think
I
it'll
think
be
that-
clear.
you are being clear.
Yeah,
Okay.
and I think it's important to point out that that's a product of the statute. So I think Dr. Fletcher earlier read the definition of proportionate per pupil basis, and that definition that's in statute makes no adjustment for resident versus non-resident students. Whatever the enrollment of the charter school is, whatever its average daily attendance is, regardless of whether or not those students are residents of that district, is included in the proportional per pupil basis that drives the seat calculation and the local transfer of funds and any additional funds that Associate Commissioner Kinney has discussed.
I see. So you would get seat funding for those students.
Yes.
Dr. Kenny, one other question. So when they start the charter, they're going to go on a projected membership, and I read that projected has to be a minimum of 100. So for the first semester, in theory, a charter school could get funded on 100 students. Say 50 show up, the January move forward, they get funding on 50, but there's no adjustment for the excess money that's been sent to the charter for the first semester.
I don't believe so, because it talks about adjusting in January. It doesn't talk about adjusting and retroactively to pick up from the first day of instruction through December.
So there's no cap on, I could say I'm going to start the charter and have 300 students, and if 75 show up, I've received 225 students ADA for a semester without any repercussions.
Let us take a look at that. I think literally the statute doesn't really address going back and retroactively. It just says adjusted based upon actual data starting in January.
Can I add something? The application is required to set forth sort of how many students you think you intend to enroll. So I think that becomes part of the negotiation too, or the application process, and then your contract process is maybe to look at, are those projections realistic?
Thank you, Mr. Ross, for that input. Dr. Kinney, I have one. I'd like to add on to what Superintendent Burchett said a little earlier about the 30 days. If that was changed to 60 days, if the LSAC was to make the recommendation to change that to 60 days, since that's different than what's in statute, would there be any issue with that change? Or what type of issues would you see with that change?
Let us go back and revisit the statutory language again to make sure that the 30 days only applies to state transfers. We would want to do that first. And then if the statute itself doesn't say that we are kind of locked into that 30 days, of course, we're happy to take that into consideration as we move forward, an alternate number of days. From a local revenue receipt standpoint, local revenues comes in at different times, different amounts, and so we're happy to take that into consideration as we present to the state board.
Thank you for that. Other questions for Dr. Kinney? I think Dr. Kinney, you got a few more slides to go.
Got a few more slides to go. So I think we're on failure to timely transfer funds. So again, straight from the statute, the first paragraph, failure to transfer required funds for every 5 days late results in a fine to the violator of not less than 5% of the total funds per funding period to be transferred. Those fines get transferred to the public charter school. The statute says not less than 5%. And so you'll see what KDE has put in the regulation is a fine of 5%. So it can't be less than 5%. So we have put 5% of the funds to be transferred in Section 6 of the regulation. Next slide, please. So we've kind of gotten to the point where we've gone through a lot of the statutory requirements, and I've highlighted a few things along the way in the regulation. Appreciate the input and feedback so far of things that we've talked about. We do have new language that we have added in section 3 of the regulation related to deadlines. So if we can go to the next slide, we'll now talk to you about 2 regulatory deadlines that we have included for your feedback. So, but these are in both the emergency and the ordinary regulation. They mirror each other. In section 3, paragraph 2, as a condition of receiving funding beginning with the 24-25 school year, the charter school shall have an approved contract prior to February 1st, preceding the charter school's first instructional school year. And the rationale for inclusion of this is we really wanted to have an opportunity for those charter school applications to be received and approved well enough in advance of the cycle that school districts already find themselves as far as funding determinations and calculations. So in the springtime, of course, you all are working on your budgets for the next school year. KDE is also providing you information on SEEK and other opportunities. And so it made sense to us to put in a deadline starting again in 24-25 for all the contract to kind of be nailed down by February 1st so that we could all start working on what the funding would look like. Now, we did that in 24-25 instead of 23-24 simply due to the timing of where we are in the regulatory process already. It seemed that would be a very, very quick turnaround for both local school districts, authorizers, and charters to make this deadline by this year in order to open in school year 23-24. But certainly by including this in the regulation now for that next school year, everyone would have adequate notice that everything kind of needs to be buttoned up by February 1st. So let me stop there and see if anyone has any questions about that. I would say this is a new thing that KDE has added, which is not specifically in the statute itself.
Dr. Kenny, that was my question as far as the February 1st. That is a deadline that that KDE added as it's not actually set forth in statute, but this is something that KDE added in regulation, correct?
That is correct.
Are there any other areas where KDE added something that's above statute?
Yes, and I'll get to that one next. It's also contained on this slide. And the reason that we did add this first provision that I've highlighted is because there really isn't a deadline by which the charter school contract has to be approved. There is some reference that each authorizer kind of comes up with their own schedule of what that will look like for authorizing, but this is directly tied to receive the funding. You have to have it all completed by February 1st of the year preceding the charter school's first instructional school year. Otherwise, there's nothing in the statute that creates a date certain. So that was our thinking by adding this to the regulation.
Dr. Kenny, another question unique to the pilot. If a authorizer authorizes a charter, is the district of location required to approve a contract?
I'm going to turn to Todd and let's see if he can help us on that question.
So the charter contract or the charter itself is an agreement between the authorizer and the charter school governing board. Those would be the parties to the contract. So I think the answer to your question, Superintendent Borchers, is no.
Okay.
That district of location would not be party to it.
Okay, thank you.
I have a question, Superintendent Borchers, that you may be able to answer. Has Northern Kentucky University accepted the role of authorizer at this point?
Northern Kentucky University has been collecting data from community members. They've yet to speak to the Northern Kentucky Superintendent Organization. That meeting's scheduled for late October with a decision by February or by November. So we've yet to have any of these questions answered from a possible authorizer, Dr. Fletcher.
Superintendent Borchers, if at all possible, and if you wouldn't mind, I'd like an invitation to that meeting if Northern Kentucky does meet with the superintendents, if you don't mind.
Absolutely. No
Thank
problem.
you. Other questions for Dr. Kenny or even Mr. Ross?
Chair Fletcher, also contained on this slide is an additional provision that KDE has added to the regulation. And it reads, the district of location, with the assistance of KDE, shall provide the charter school with a written estimate of the projected funding that will be due to the charter school through December of the first instructional year. And we've included on or before February 1st, preceding the charter's first instructional year. The reason that we did that is because in order for the charter school to have a better chance of a realistic application to the authorizer, we felt it was important that the district of location, with the assistance of KDE, provide the charter school with an estimate of projected funding. Now, you're not going to be able to project everything that a charter school, but anything that would be within receipt that the district of location would typically receive, then you could help with the written estimate, along with KDE also providing input on that written estimate. This was really to try to mitigate applications coming in that are not realistic in nature from a funding standpoint.
Okay, other questions for Dr. Kenny? Dr. Kenny, I have a question that I'm afraid I know the answer to. Is it possible to include in regulations some type of hold harmless? In other words, when I say hold harmless, let me define that. In other words, that a district cannot lose more funds than what the students that they have going to the charter school. A district or location can't lose any more funds than what they would as if the student stayed in. And again, there's a lot of gray there, because what happens for a district maybe that's 3 counties over that allows it to come in, and then the district or location is responsible for that child. But of course, we also see the seek for that child. So I guess my question is there any way that we can add that into regulation, but and still stay within statute requirements?
I would think arguably that would exceed our statutory authority to do that. But again, I'll turn to Todd Allen and see if he has a different viewpoint.
Yeah, I tend to agree that that's probably beyond the statutory authority that we have for rulemaking in this situation. So the General Assembly with House Bill 9 set forth a very detailed and comprehensive scheme for the funding transfer to occur. For us to put a cap on that would probably not be within our authority to do. If the statute calls for and allows what you're talking about to happen, Dr. Fletcher, I don't think the state board or the department has the ability to lower that amount. I will say, I think it'll be interesting for us to take a look at that and see if that is possible based on that definition of proportionate per pupil basis. So your charter school ADA is the numerator, but that amount is also included in the denominator, because those students are included also in the entire district's ADA. So with that same number being both in the numerator and the denominator, and I admit I'm not a math expert, I don't see how that's mathematically possible right now, but we'll take a look at that and play around with those numbers.
Well, based on that definition, it also includes every other student in the district of locations. So if you have a smaller, if your attendance is less than the charter schools, it would still make sense that overall that you would it would be possible for that fraction to be above 1. Therefore, sending more funds to the charter school than what the district of location would be able to keep, in my opinion. Okay,
Well, it's
questions?
absolutely true that yes, if the enrollment at the charter school were greater than the enrollment in the traditional schools, then the charter school is going to get more, over 50% of the share of the SEEK.
Again, the statute is not based on the membership. It's based on average daily attendance. So it's a percentage of the students. So then in that case, membership doesn't matter. The attendance does. The attendance rate, if you will.
And also, if I understand correctly, we receive the SEEK funds for these students, but I guess we would receive all the add-ons as well. That's what I'm, okay.
Yeah.
Ms. Kenny or Dr. Kenny, who would monitor the attendance at a charter school? Is that a reg is that one of the regs that are they going to be under the same audit processes as a public school?
You know, we're talking about what audits would look like for charter schools, whether that would be part of the district, and we would do the charter separately and look at their calculations. We haven't worked all the way through the logistics of what that would look like, but we certainly would be looking at the charter schools as a component of the local school district.
Last question, because I've been sent this question. I apologize, Dr. Kenny.
You're okay.
So an authorizer gets the 3%. An authorizer in this pilot could make a district of location. They're going to send funds to the charter, and then 3% of those funds go to the authorizer, and the authorizer doesn't have to do any of those calculations or any of that paperwork. They do have to oversee the charter, but they do not do all of these financial calculations that we're talking about. So the district of location will gain no percentages of doing that charter under that scenario, correct?
The way the statute is currently written, there is no, for those authorizers that are not the district of location, they would receive the up to 3%. They could negotiate a lesser amount, I guess, with the charter school, but they would receive that up to 3%, and the district of location would not receive any of that authorizer's fee. The district of location has separate statutory responsibilities independent from the authorizer in that case, but would not receive the benefit of an authorizer's fee.
Dr. Kenny, on the back to the attendance calculation piece and the auditing, and I just for my clarification, are charter schools required to use the state mandated software such as Infinite Campus and Munis for public reporting? So they will be in Infinite Campus and doing everything like we would do, a normal school would do. And KDE could access that information at any time, and also that applies to Munis as well.
They are required to use our state systems, Infinite Campus and Munis. Of course, as you know, as districts, KDE does not have independent rights to access your Munis accounts. We do that with your permission.
Sure.
So
yeah.
we would look to a similar arrangement with the charter school.
Okay, thank you for the clarification. And one other question, are charter schools, and I know I'm not sure what the waivers are and what they aren't, but are charter schools required to participate in the same state and federal accountability system as regular common schools, public schools?
You're getting into accountability, which is out of my bailiwick. So I'm going to ask either Todd or Rhonda Sims is on here. We got lots of accountability people.
Yes, the charter schools are required to participate in the state assessment and accountability system.
Thank you.
Okay, other questions? Harry, your previous question, accountability prior to that, what was your previous question? If you wouldn't mind repeating that one again, just for my benefit. You had right before the accountability, you had another question. What was that again?
It was a question with regards to will they be mandated to use the state required softwares of Infinite Campus and Munis for public reporting to obviously the Munis data rolls up for reports to the legislature and so forth. So,
and my question goes along with that. Would the authorizer have access to that Munis, the Munis and Infinite Campus information? So example, if a local board of education authorized it, would that school system I also have access to the Infinite Campus records as well as the Munis system for the charter school?
I think that would have to be something that would be negotiated between the authorizer and the charter school.
Sounds fair. Okay, other questions? Dr. Kenny, any additional information, or are we?
I think we're at the end of our presentation. We didn't go section by section in the actual regulations themselves, but we have pointed out those provisions in the regulation that are different from the statutory requirements in our presentation. So, but happy to answer any additional questions.
And again, Dr. Kenny has pointed out that, again, that KDE has met the minimum requirements of statute, but also has pointed out the dates. That was also, there was one other question I had about the 5%. I think that the statute requires a minimum of 5%.
The statute says of not less than 5%.
Mm-hmm.
And so KDE in our regulation has said 5%.
Okay.
So it can't be less than that. So in our regulation, we have essentially said 5%, no more.
Okay. And I do appreciate that. And that goes back to failure to transfer funds for every 5 days late result as a fine to the violator of not less than 5%. Now, is that 5 days late? Is that statutory, or is that is statutory?
That is statutory.
Okay. Other questions or comments from LSAC members?
Dr. Kenny, could I ask one more? I apologize. We talked the local funds. You had mentioned, but we're talking IRBs and utility taxes, even things that a board may have negotiated or approved above what is normal in the normal property evaluation. Is that correct?
I'm trying to pull the exact statute language. The statute says all taxes and payments in lieu of taxes.
Okay. Thank you very much.
Dr. Kenny, one thing that as it relates to local funds, I think that the regulation that KDE is setting forth has a 30-day limit. We would not violate regulation if we increase that to 60, especially when it relates to local funds. Would you agree with that or disagree?
We're going to go back and look at the statute itself to make sure that it does not say, because I think it said the state funds transferred by the state, but if I could ask for some help either from Matt or Todd to look at the statutory requirements around the transfer and see if we can be more flexible without violating the statute on the local fund transfer.
Sure, let me read to you from the statute what it says.
Thank
Funds
you.
identified for transfer by a district of location to a public charter school under this section shall be transferred throughout the school year according to a schedule determined by the state board. The scheduled dates shall be within 30 days of the dates of state disbursement of funds to school districts. Based on that, I'm not sure that we can extend the local portion to 60 days. It seems that the dates for the transfer of all funds must be within 30 days of when KDE transfers state funds to the school district.
Okay. Other comments from our members of LSAC or questions? Again, I'll make another comment, and my vote will be will reflect this also. You know, our jobs as superintendents is to work for the students in our districts, not only the students in our districts, but also in our Commonwealth. The limited experience I've had in talking with folks in a charter system, it often creates a system of haves and have-nots. And more often than not, the have-nots have been in the public school system. Again, I'll go back to the fact that I believe charter schools puts public schools at a disadvantage when it comes financially. We are looking at ways of trying to and help our students to be career college ready or post-secondary ready now. We're looking for ways to add more dual credit options. We're looking for ways to add deeper learning opportunities to our students. Unfortunately, that costs money. And anything that takes away money from the public school system limits what we can offer our students. So again, I do question whether or not the funding mechanism is constitutional. But again, I'll say this, I do believe that KDE has met the requirements of statute in their regulation with the addition of some deadlines, which make perfect sense to me at this point. But again, overall, I do question whether or not charter schools, particularly the funding, is constitutional. As a local taxpayer, I would have issues with the funds that I'm paying to a school district to go to a charter school that may be receiving funding from other entities that are private entities. Why would that need to transfer? So again, those are my comments. I'll open the floor up to any other comments before we do a motion. Okay, hearing no other comments, do I have a motion to approve 701 KAR 8050E and 701 KAR 8050?
Understanding that it's just based on the requirements for KDE to put this into regulation, I make a motion. Kelly Ransdale.
Superintendent Ransdale, so noted. Again, just from the requirement standpoint that KDE must promulgate regulation from statute, that is your motion, and I appreciate that. Second motion, seconded. Anyone second that motion?
This is Mike Borchers. Based on those requirements that were required, I think Robin, I would like to note that Dr. Kenny has done her due diligence and answered all the questions thoroughly that we've asked. I would second that motion, but I would have comment on my vote.
Okay, we have a motion and a second. Dr. Meredith, if you could do the roll call vote, please.
Mike Borchers.
Based on the requirements, I'd vote yes, but I'd like to note that I feel there are multiple flaws in this statute, and I feel that any district being required from an authorizer to take on a charter without any of their input is totally unconstitutional.
Harry Burchett.
Harry Burchett, I would like to make my vote and comment as well. As a requirement of the department's required duty to promulgate regulations, I will vote yes. The department's done due diligence with this. But again, I too believe there is serious constitutional issues with local taxing authorities levying taxes and then transferring that to unelected bodies to expend. I don't believe that is the way that our founders intended this to work, and I think there's serious constitutional issues with Kentucky's constitution. So with that, I will vote yes to advance this on.
David Cox.
David Cox, yes.
Robbie Fletcher.
Again, comment, I will echo Superintendent Borchers and Superintendent Burchett with additional comment. I do not believe this is a good system. Charter schools in general, particularly the funding, is good for the public school student, any public school student. So again, I will vote yes, because I do believe that Kentucky Department of Education has done their job to align regulation with statute.
Will Hodges.
Will Hodges, would like to note that, as the others have said, I believe the language KDE has shared with us today meets the requirements outlined by the statute and what's presented in House Bill 9, but I do believe the funding measure is flawed. So I do vote yes with that comment.
Sheila Mitchell.
Sheila Mitchell, I'd like to say thank you to the department and the commissioner for your comments and your diligence in working on this. But I must vote no, not just from the purpose that I disagree in how it's written. And again, I echo the comments of the other superintendents, but my vote will be no.
David Raleigh.
David Raleigh, I vote yes, with my comment being that I echo the sentiments of my previous colleagues. Thank you.
Kelly Ransdell.
Kelly Ransdell, I vote yes. I'd like to just add that I appreciate the leadership of Chair Fletcher around this issue and Commissioner Glass and all the work by KDE, but also echo the words of the other superintendents that I do not agree to the constitutionality of the legislation.
Chair, that is 7 yes votes and 1 no vote, so the motion does pass.
Thank you, Dr. Brewer, and I'll close before we ask for adjournment. This is a tough topic for all of us on this call. We have a lot of issues with how charter schools are being set up, with how they're being funded. I think superintendents on this meeting that you've done an excellent job of pointing things out that maybe even I didn't think of. So again, we did not vote for charter schools today. Well, in my opinion, we voted for the process. We voted for the work of KDE, and we voted that KDE followed a statute with the regulations that they're promulgating. So again, at no point would I like to say that I voted for charter schools today, because I didn't. And I believe many on this call would feel very same, and their comments will reflect that. Again, I do appreciate each person on here, your work. It's obvious that each of you did a lot of research on your own, a lot of great questions, and also appreciate your reaching out to people that you represent. So again, with that being said, we'll ask for a motion for adjournment.
Harry Burchett, I make a motion, we adjourn.
Motion, Mr. Burchett, have a second.
So moved, Mike Borchers.
Mr. Borchers, Superintendent Borchers, with a second, and we stand adjourned. And I want to thank each of you for the work you've put into this for the past few days. We've had a busy 2 weeks. And the last thing I will say is we would like to have the November 22nd meeting in person. We'll leave it open for an option for it to be hybrid. But it would be good for each of us to get together on the next one. Then we can make a decision about meetings moving forward. So if possible, and if you're able to on November 22nd, and if it pleases the commissioner to allow us to use the Sauer building office space, let's have the next meeting in person, but we will leave the option open for virtual for those that cannot attend. Would that be okay, Dr. Glass?
We'd be pleased to host you, Mr. Chair, and also thanks to the members of the committee for the discussion today. I appreciate the sentiments expressed and understand it was a difficult process for you to go through. It's been difficult for us as well, but we're doing what we're required to do under the law, and so I'm grateful for that. Directly to your question, we'd be delighted to host you, whatever y'all want to do.
Thank you, Dr. Glass, and again, we thank you, and we thank your staff for the hard work they put forward. Thank you to all. And until November 22nd, we're adjourned.